from that. I'm about to switch my screen to that. Let me get my bookmarks out. 1 second. Just want to say thanks for tuning in to this webinar, National Passport webinar. I know you guys could be doing a whole lot of other things today on your Saturday, but you saw that this was important for you, so you did this, which says a lot about your wanting to be free from your current situation for doing that. All right. Give me a second. I'm just trying to get my Ben Tillman speech up. Oh, that's not the one I want. All right. Ben Tillman 2. Let's see if this is it. There it is. All right. I'm about to share my screen with that speech. And you can find this online. It's there. And I have a certified copy of it. But you can see up in there is historymatters.gmu.edu /the letter D /55. So you could type that in and that speech will be there for you. All right. Ben Tillman is a, let me move this around so I can see. He was a senator from South Carolina, and he is the one who got you guys out of who spearheaded getting us out of our our original titles. It was the only way they can do it because we outnumbered them so bad. But I'm trying to shrink this down a little bit. All right, there it is. All right, let me do is make sure you guys can see it. All right, there. All right, here we go. All right, I'm gonna start here. I'm gonna skip this top part and start right here where it says, and Senator John C. Spooner of Wisconsin said, we had taken their rights away from them. He asked me, was it right to murder them in order to carry the election? So what he's saying, they took the rights and they committed murder to take these elections because we had the power at that time. And as I read on, you'll understand why you need to get this nationality straightened out, because the more and more people I see that's getting the passport, new things are happening just off of that alone without them even doing anything. All right. Then he says, I never saw one murdered. I never saw one shot at an election. It was the riots before the elections precipitated by their own hot-headedness in attempting to hold the government. So he's saying that they wanted to hold the government, meaning they had control of the government. That brought on conflicts between the races and caused the shotgun to be used. That is what I meant by saying we used the shotgun. I want to call the senator's attention to one fact. He said that the Republican Party gave the Negroes the ballot in order to protect themselves against the indignities and wrongs that were attempted to be heaped upon them by the enactment of the Black Code. I say it was because the Republicans of that day, led by Thad Stevens, wanted to put white necks under black heels and to get revenge. There is a difference of opinion. You have your opinion about it, and I have mine, and we can never agree. I want to ask the center of this proposition in arithmetic. In my state, there was 135,000 Negro voters or Negroes of voting age and some 90,000, 95,000 white voters. General Canby set up a carpetbag government there and turned our state over to this majority. So they're admitting we always were the majority at that time. Now, I want to ask you, with their free vote and their fair count, how are you going to beat 135,000 by 95,000? How are you going to do it? You had set us on an impossible task. You had handcuffed us and thrown away the key, and you propped your carpetbag Negro government with bayonets. So they're saying not only did we have the government, we also had the military. Because now he goes on to say, whenever it was necessary to sustain the government, you held it up by the army. So Right there. So all of the history that you've been reading about us is one big lie. But let's keep going. Mr. President, I have not the facts and figures here, but I want the country to get the full view of the southern side of this question and the justification for anything we did. We were sorry we had the necessity forced upon us, but we could not help it. And as white men, we are not sorry for it, and we do not propose to apologize for anything we have done in connection with it. We took the government away from them in 1876. Now, if they had the government prior to that, wouldn't he say, well, we took the government back from them? He said, we took it away from them. It was 1876 that they took it away from us. We did take it. If no other senator has come here previous to this time who would acknowledge it, more is the pity. We have had no fraud in our elections in South Carolina since 1884. There was no organized Republican Party. There has been no organized Republican Party in that state. So not only did they take the government away from us, and they're admitting that they committed fraud up until 1884. You see? Then it says, we did not disenfranchise the Negroes until 1895. 1895 is a very important year because around that time, most of your states created a new constitution right around 1895 or later. So that's why I stress, try to get a constitution before 1895, pre-1895. But sometimes constitutions are from 1895 forward do have things in there that you can use. It just depends on the situation. Now, then we had a constitutional convention convened which took the matter up calmly, deliberately, and avowedly with the purpose of disenfranchising as many of them as we could under the 14th and 15th Amendments. This is very important, what he just said. So he's saying the 14th and 15th Amendments is the two amendments that is used in order to take you out of your nationality. And later on in this webinar, you will see the proof that that's what they're using. All right. We adopted the educational qualification as the only means left to us, and the Negro is contented and as prosperous and as well protected in South Carolina today as in any state of the Union south of the Potomac. He is not meddling with politics, but he found that the more he meddled with them, the worse off he got. Now, this still holds true today. They're still trying to keep you from voting, although you don't really vote in those polls. But politically, they position themselves in a way that you can never have a voice. Why is it that people of color, or as they call us, blacks or Negroes today, why are we the only ones that they try to position out of politics? They don't stop Koreans. They don't stop the East Indians. They don't stop any other ethnic group or racial group from having a voice other than our people or us as a people. There's only one answer to that. That's because you are the people, the real people. They are the trustees. Sorry. What did I do here? Oh, my screen did this old double thing, which it's never done. Okay. See if I can get it back. Screen acting funny. Settlers came in. But instead of being honorable trustees, they started reclassifying and calling other people indigenous. Now, well, right now they call them American Indians to keep you from having rights. So let's go to, I'm not going to read anymore. That's really all I wanted to read on that. You guys can go back and read the rest of that speech. But the 14th and 15th Amendment is the problem. All right. Now let's go to this here, right here. Certificates of non-citizen nationality. What I'm going to do is, I was thinking about doing that now. I'm going to hold off, and after I show you how to fill out the application, because I want to do that after and explain to you, because you're going to get proof of whatever you do once you do your passport. So let's go to the DS11. Get your DS11s out and type in the chat once you're ready with your black pen, because you're going to fill this out with me. And we'll come back to this page right here after, because it all ties in with something else, and I don't want to kind of skip around. So there's a reason in prior case, okay, the real living man. Number three, this is not going to body. Say once the United made identity, we couldn't determine it. Property application, you have his info, North Carolina. Before you're gonna put New York, USA, U.S. citizens too. I see it's not a genuine current photograph of me, and I have read and understood the warning on page 1 of the instructions to the application form. So they're saying you take an oath to be a U.S. citizen unless you have done something in the acts and conditions and given them an explanatory statement. So you do nothing over here. You don't cross out anything like people have taught you. Do not touch this, because it is fine the way it is if you understand what it's saying. So let's go to page 4. So flip over the page which got your parents' information on it. Flip that page over. That's why I told you to get the one from the post office. Because if you did it online, the acts and condition is not going to be on the back of that page. All right. Now, as you can see, I got some stuff happening over here on the acts and condition. I'm actually doing something here. Let me make sure. I don't want to lose y'all. There's your birth certificate. We'll get to those questions later about the birth certificate. I'll run that down, but just remind me if I don't talk about it. I'll talk about that. Let's just stay with the flow of what I'm doing right now. All right. Okay. Now, action conditions. Everybody got their page flipped over with me, following along. This is crucial. Got it, got it, got it. Josh says he got it. Some people got lazy fingers. They don't want to tell me nothing. I know more of y'all, okay, B, yeah, see. All right, good. All right, I just want to make sure everybody's with me. I don't want to get to the end and we are. Oh, I missed that. Oh, make sure my screen's showing properly. All right, so what does the acts and conditions say? If any of the below mentioned acts or conditions have been performed by or applied to the applicant, the portion which applies should be lined out. And a supplementary explanatory statement under oath or affirmation by the applicant should be attached and made a part of the application. Now, there's clear instructions here. It says, if any of these below mentioned, the next two paragraphs apply to the applicant, they need to line out what applies and have a supplementary explanatory statement under oath or affirmation by the applicant should be attached and made a part of this application. So, what applies? Okay, start getting them pens ready, because I'm going to tell you what to line out. All right, but I'm going to read it first. You already see what to line out, so go ahead and start lining it out as I have it on the screen where you can see what to line out. Do not underline. Line through it. Line out, because you're lining out what applies. Most people see lined out, they think it don't apply. They get confused. I've talked to people who have been teaching this for years and tried to explain this to them, and point it out. Show them in the dictionary what lined out is, and they still look at me like I have three heads when I say this. This is how programmed their minds is and what their beliefs are. So I let them have it, and I went on about my way. And those very people that teach this don't have testimony about student loans disappearing or cases disappearing. All right, here we go. You're gonna line out, I have. But for the sake of this, I'm gonna read through it and then go back and show you the lineouts. I have not since acquiring United States citizenship. See, it says I have not since. See, they're playing with y'all with these words. Acquiring United States citizenship, nationality, been naturalized as a citizen of a foreign state. So right here, if you don't line out the proper things, you're saying that you had acquired United States citizenship. So you got to correct that. You never did acquire U.S. Citizenship. You were born in your country, which is your state. If you're born in Georgia, that's your country. I proved that through the GPO manual. All right. Then it says, taking an oath or made an affirmation or other form of declaration of allegiance to a foreign state. So with this line, this is what you're going to line out. You're going to say, I have taken an oath, made an affirmation, formal declaration of allegiance to a foreign state. What is the foreign state? The foreign state is your status of being under the direction of God, and second, being born in a state outside of the United States. That is the foreign state. All right? So you're going to line that out. Then it goes on to say, entered or served in armed forces of a foreign state, accepted or performed the duties of office, post of employment under the government of a foreign state or political subdivision thereof. And it continues to say, made a formal renunciation of nationality in the United States. So you need to line out. You made a formal renunciation of nationality in the United States. What are you renunciating? You renunciating that U.S. citizenship. Right? That's what you're lining out. And that's really all you need to line out for this paragraph right here. And then it says, or before diplomatic or consular office of the United States. So some people get their passport at a what do you call it? An embassy. So that's where that would apply. So, okay. But most people don't have that issue, so they don't do that. All right. Or been convicted by court or so many people see success in other people's and they want that success, but they don't want to break old habits. You'll never have success that way. If you're going to stay the same person that don't have success now, you're not going to get success being that same person. You're not going to get the success hanging out with the same people. You're not going to get the same success with the same entertainment habits that you had before. You're going to have to give those things up. You got to give it all up. Peace, peace. What's up? What's up? All right. Thank you for showing up on December the 23rd, Monday. Oh, I didn't put the Telegram thing on. Please forget. I've been forgetting lately. Forgetting. All right. Let me get that going and then we can get into it. Well, so right before what took me so long to chime in and get in, I let that recording play is because I was reading something that the appeals court had lifted the stay on the corporate parency act. They lifted it like a couple of hours ago. So they can actually go ahead and enforce that. So apparently you're going to have to go down there and register if you have an LLC corporation or one of the businesses that falls under the rules. You're going to have to go and report. But when I went to the actual website of the corporate
FinCEN. It's FINCEN. It was saying it still had that. Let me go to the website, see if I can find it. It still had that notice saying that it was voluntary, right? I'm gonna refresh the page. Maybe they changed it by now. They have. Like I was just looking at it like 10 minutes ago and they just updated it. Many companies are required to report information to FinCEN about the individuals who ultimately own or control them. Uh FinCEN began accepting reports on January 1st, 2024. They just updated. This literally said something else a few minutes ago. I should have like shared the screen, let you see it. So they updated it because the Fifth Circuit Court lifted the stay, but the litigation is still ongoing. So, let me fix my camera here. The litigation is still. Uh oh, I did something. It's still ongoing. So what I was trying to do is like actually get the case where they're talking about this. So, well, let me read this to you. This is what the basis of the case. They're saying it's unconstitutional to require you to report and give all kind of ID of your company. And why do they want to do this? So they can go after people. They say it's for financial crimes and, money laundering. But it's really the people that's really going to take the hit on this are the small people, the small businesses. That's who's going to take the hit. So basically, what you probably if you set up trust and you set up your nonprofits because they don't have to do anything. Oh, like me, I tell you, set up your temples and your churches and start doing business out of that. Companies do businesses with trust, churches. They do business with you. Um, because let's read it. It says the National Federation of Independent Business applauds today's decision. In the case Texas Top Cop Shop Inc. et al. Versus Garland et al. At the U.S. District Court for the Eastern District of Texas. The court granted NFIB. Let me make sure y'all could hear me. I didn't do that. Mic check. Um, The court granted NFIB's request for a preliminary injunction blocking the U.S. Department of Treasury from enforcing the Corporate Transparencies Act beneficial ownership information reporting requirements. This ruling is a huge victory for small businesses nationwide. Just in time, said Beth Melito, executive director of NFIB's Small Business Legal Center. For many Main Street businesses, they were a mere 4 weeks away from the deadline to file their information. In accordance with the CTA, the BOI reporting requirements are a harmful invasion of small business owners' privacy and a misuse of their valuable time. Thankfully, the court agreed and granted a preliminary injunction giving small businesses owners a reprieve from this burdensome rule. They moved really fast with this appeal, though, because it was just like a couple of weeks ago. NFIB's lawsuit argues that the CTA is unconstitutional in that it exceeds Congress' authority over the states. And it does. Because the federal government is telling all of the states to do this. You got to make people do it. If the states are sovereign individually, how are you going to tell the states how to run their business at their secretary? You got to give us this information. But the reason why the states go along with it, because they're in bed with the government. They get money for the government. See, this is how the federal government gets their claws into people. They start off with giving them a benefit. And one of the biggest benefits that states get from the government is through enforcing child support. So now they're getting that benefit. They get money for that from the government. Well, now when the government comes up with stuff like this, now they got to go to all of the businesses that are doing business with them, registered under in their state, and force them, or really can't force anybody to do anything. You could just threaten them to do something. And if they don't do it, you're going to face all of these fines. If I don't tell you, what's the sense of setting up private businesses if you got to tell the government who owns the business? Who's the beneficial owner is? What's the sense in doing that? Like, why set up a private business? And you have states like Delaware, Wyoming, where you can set up your business and be private from, so people can't see who actually own it. But the government can reach down and get that information by way of setting up these what you call invasive laws. Thankfully, NFIB's lawsuit argues that CTA is unconstitutional and that it exceeds Congress over the states, improperly compels speech, and contradicts the right of anonymous association guaranteed by the First Amendment, and violates the Fourth Amendment by forcing disclosure of private information. And it does violate that, because if you fill out that report, when you fill out that report, you sign it under penalty of perjury. So anything that you're like basically voluntarily giving them a license to come after you if they could say something you wrote on that report is wrong. It's like incriminating yourself. Providence NFIB partnered with the Center for Individual CIR and filed the lawsuit with the Texas Top Cop Shop, Datacom for Business, Mustard Seed Livestock, Russell Strayer, and Libertarian Party of Mississippi, because NFIB, its nearly 300,000 members, were a party to this case. The judge blocked enforcement of the BOI reporting requirements nationwide. This reaffirms the power that NFIB members hold when they stand up and break out in protection of their rights. The NFIB Small Business Legal Center protects the rights of small businesses owners in the nation's courts. NFIB is currently active in more than 40 cases in federal and state courts across the country and in the U.S. Supreme Court. Well, they were effective for a couple of weeks, but I have a feeling that another appeal is going to come to that decision, and let's see what happens with that. So now, December 23rd, Court of Appeals overturns the order blocking enforcement of the beneficial ownership information reporting requirements. The National Federation of Independent Business, NFIB, is extremely disappointed by today's decision. In a U.S. Court of Appeals for the Fifth Circuit, in NFIB's lawsuit challenging the Corporate Transparency Act, Texas Top Cop Shop, Inc., et al. Versus Garland, et al. Earlier this month, the U.S. District Court for the Eastern District of Texas granted a nationwide preliminary injunction in the case, which prevented the U.S. Department of Treasury from enforcing CTA. Today's decision nullifying that injunction allows the Treasury Department's Financial Crimes Enforcement Network to enforce the CTA and its beneficial ownership information reporting requirements while our lawsuit proceeds. Because of this decision, small business owners must scramble to meet reporting requirements of this egregious statute. Enforcing a January 1st deadline for compliance will mean massive chaos for our nation's small businesses, said Beth Melito, executive director of NFIB's Small Business Legal Center. The district court is granting the preliminary injunction, rightly recognized that the BOI reporting requirements would have devastating consequences for small business owners. Make no mistake, NFIB is already working to quickly appeal this terrible decision and provide our main streets with a reprieve from this harmful mandate. More than 32 million small businesses throughout the country will once again be subjected to the burdensome statute, including the nearly 300,000 NFIB members business represented in this lawsuit. NFIB supports the repealing Big Brother Overreach Act legislation that will repeal the CTA and permanently relieve small business of the beneficial ownership requirements. The NFIB Small Business Legal Center protects the rights of small business owners in the nation's courts. NFIB is currently active in more than 40 cases in federal state courts across the country and is in the U.S. Supreme Court. So it was appealed. Now let's pull up. Let's look at the rules. I did this before on another. Um, did I close that? Let's go to here. It is. Let's find. I did this show already. I did this on the show, but let's look at the rules. Okay, let's see. Let's hope this does it. Let's look at. So the rules is, when do I report? If your company was created or registered prior to January 1, 2024, you have until January 1, 2025 to report BOI. If your company is created or registered in 2024, you must report BOI within 90 days after receiving actual public notice that your company's creation or registration is effective, whichever is earlier. If your company is created or registered on or after January 1st, 2025, you must file BOI within 30 calendar days after receiving actual public notice that its creation or registration is effective. Any updates or corrections to beneficial ownership information that you previously filed with FinCEN must be submitted within 30 days. So, so let's look at. So when you get these things, I'm I'm trying to get the actual rules. Let's see. Who has companies required to report are called reporting companies. Reporting companies may have to obtain information from the beneficial owners and report that information to FinCEN. Your company may need to report information about its beneficial owner if it is a corporation, a limited liability company, or was otherwise created in the United States by filing a document with a Secretary of State or any similar office under the law of state or Indian tribe or foreign company and was registered to do business in the U.S. state or Indian tribe by such a filing. So they're trying to say if you have to file something with the Secretary of State, you got to file, but that's not all the way true. Because there's certain businesses that do file. Like for instance, in the state of North Carolina, you file what you call your DBA or assumed name certificate at the Secretary of State level, as well as the county. That business doesn't have to file. See, let's see. Okay, this might be what I'm looking for. All right, small entity compliance guide. So let's get the English version. Let me give you all these links. That's the link that I'm pulling up, and click the English version. This is the this is the official beneficial ownership information reporting requirements. So, is my company a reporting company? Number two, that would be page two. Is my company exempt from reporting? Page four. So let's go to those pages. Not all companies are required to report BOI to FinCEN under the reporting rule. Companies are not required to report only if they meet the reporting rule definition of a reporting company. So let's see, what is an import reporting company? See, they make this very hard for people to read. I just want to go to, okay, here it is. Here's the exempt companies. All the exempt companies that can, I'm just skimming right now because this list is looking a lot different from the first time I read this. It's two entities missing here. But it doesn't matter because still they're not considered a reporting company. A trust is not considered a reporting company. They got this flow chart. Is a company a corporation? Yes. Is a company a limited liability company? Yes. Was a company created by filing a document with the Secretary of State or any similar office under the law of state or Indian tribe? So maybe a domestic reporting company. They got this little flow chart. But then they skip down. Let me share my screen real quick. These are the companies that are exempt. You got number one, securities reporting issuer, governmental authority, bank, credit union, depository institutions, holding company, money services businesses, broker and dealer securities, securities exchange or clearing agency, other exchange act registered entity, investment company or investment advisor, venture capital fund advisor, insurance company, so state licensed insurance producer. So Commodity Exchange Act registry entity, accounting firm, public utility, financial market utility, pooled investment vehicle, tax exempt entity. 19 would be your church, your temple, your mosque. Entity assisting a tax exempt entity, large operating company, subsidiary of certain exempt entities, inactive entity. So if you got a company that's you registered with the Secretary of State but it's inactive, it doesn't have to report. So if an entity meets the criteria of exemption number 18 and is formed under the laws of a foreign country, the entity is subject to separate reporting requirement. These companies are referred to as foreign pooled investment vehicles. That has nothing to do with you guys. And then they have a breakdown of all of defining the exemptions. So let's go down to something that may apply to you. Mm. All these pooled investment tax exempt entity. The entity is a organization that is described in Section 501C of the Internal Revenue Code, determined without regard to Section 508A of the code, and exempt under tax under Section 501A of the code. The entity is an organization that is described in 501C of the code and was exempt from tax under the 501A of the code, but lost its tax exempt status. It says An entity qualifies if any of the following criteria apply. So, number one would be it. And the entity is a trust described in paragraph 1 or 2 of section 4947A of the code. Now, isn't that crazy that it says that's, remember I told you they was missing something. Now I go over here, they say the entity is a trust described in paragraph 1 or 2 of the section 4947A of the code. They are funny how they word things. So they took the trust. I remember reading that months ago and it said trust. So what I would do if I had a business, say if I had one of those businesses that was considered a reporting company, right? I would go ahead because it's got the beneficial to be considered the beneficial owner. You have to have 25% ownership or more, right? So I would, if it was me, I would make my trust the main owner of my business. Have, if I'm going to put myself as part owner at the business, because sometimes you need to be on there as a part owner, like if you're trying to get loans and things like that, you would, you know, they want to see your name on that business as the owner, right? So privately, I could show. When I talk to my members, I'll go over what you can do in that case when you're trying to get a loan. If you need to update, because you can always update your Secretary of State records. You always update that at any time. It's going to cost you, but you can update it. But I would have my trust or my tax exempt entity like my church be the owner of the business. And then I'll fill out the report and say that that's the beneficial owner. I would do it just to be safe because this all is back and forth and I'm reading this. This reads different from when I first read it. So I will put the trust down as the owner and make sure that it's more than that it has what do you call what is 70. I'll make it 80% owner and if I'm gonna put my name on there, I'll be 20% owner. Or I wouldn't put my name on there at all. I'll just put that them as the owner on my report. See, and this is the thing. They're requiring you to fill this thing out, and then they got all these civil penalties. They're making you do something, and if you don't do it, you get fined. If you do it and you willfully lie according to their standards, they come at you. So you should. This is a contract. This is a contract that has it that really contracts you into them being able to punish you. That's what makes it unconstitutional. You got to do it if you have a company. And if you don't do it, we're going to fine you. But if you do it and we don't like what you put on the report, we're going to fine you anyway. How is that freedom? They're forcing you into a box of penalties. And I understand why this lawsuit needs to go through. I'm going to look these groups up and see what they're about. Because these lawsuits really need to go through because you're telling me I have to do something. And if I don't do it, I get fined. And if I do it and you don't like what I put on there, you think I did something wrong, you can still come after me. What kind of shenanigans is that? But this is these elected officials down there that you vote into office that make these rules up on you. And the people that's going to get hurt is the small business people. The big companies don't have to do this. The people with all of the money don't have to do it. Know why? Because it's more smaller businesses, and they'll have. It's easy to go after the small people that don't have the money to defend themselves than it is to go after those big corporations. And of course, when they was writing that bill, the big corporations probably paid off those Congress and people to make them exempt. You see? But it's always a remedy. If your company is a reporting company, your next step is to identify its beneficial owners. A beneficial owner is any individual who directly or indirectly exercise substantial control over a reporting company or owns or controls at least 25% of the ownership interest of a reporting company. An individual might be a beneficial owner through substantial control, ownership interest, or both. Reporting companies are not required to report the reason, i.e., substantial control or ownership issue, that an individual is a beneficial owner. A reporting company can have multiple beneficial owners. For example, a reporting company could have one beneficial owner who exercises substantial control over the reporting company and a few other beneficial owners who own or control at least 25% of the ownership interests of the reporting company. A reporting company could have one beneficial owner who both exercise substantial control and owns or controls at least 25% of the ownership interests of the reporting company. There's no maximum number of beneficial owners who must be reported. FinCEN expects that every reporting company will be substantially controlled by one or more individuals, and therefore that every reporting company will be able to identify and report at least one beneficial owner to FinCEN. The following four sections will assist you in determining your company's beneficial owners. If an individual qualifies as a beneficial owner, information about that individual must be reported to FinCEN in a reporting company's BOI report. What is substantial control? What is ownership? What steps can I take to identify my company's beneficial owner? Who qualifies for an exception from the beneficial owner definition? Okay, what is substantial control? Reporting companies are required to identify all individuals who exercise substantial control over the company. There is no limit to the number of individuals who can be reported for the exercise of substantial control. An individual exercises substantial control over a reporting company if the individual meets any of the four general criteria. The individual is a senior officer. The individual has authority to appoint or remove certain officers or majority of directors of the reporting company. The individual is an important decision maker, or the individual has any other form of substantial control over the reporting company. See the chart below for details about this criteria. Senior officer, any individual holding the position of exercising authority of president, chief financial officer, general counsel, chief executive officer, CEO, COO, blah, blah. Appointment or move of any individual with the ability to appoint or remove any senior officer or a majority of the board of directors or similar body. Important decision maker, business such as nature, scope, attributes of the business, the selection of termination, business lines or ventures, finances such as sale, lease, mortgage, or other transfer of any principal assets, major expenditures or investments, structure, reorganization, dissolution. So that's catch all. Any other form of substantial control over this reporting company, control exercises new and unique ways can still be substantial. For example, flexible corporate structures may have different indicators of control than the indicators included here. What is ownership interest? Reporting companies are required to identify all individuals who own or control at least 25% of the ownership interest of the company. Any of the following may be ownership interest: equity, stock, or voting rights, a capital or profit interest, convertible instrument, options, or non binding privileges to buy, sell any of the foregoing, and any other instrument, contract, or other mechanism used to establish ownership. A reporting company may have multiple types of ownership interests. The following chart identifies the ownership interests Um, this is mainly about stocks, capital or profit interest, convertible interest. I'm not going to read all of that. What steps can I take to identify my company's beneficial ownership? Owners. Hold on. Sorry about that. Your company can identify beneficial owners by taking the following steps. Identify individuals who exercise substantial control of the company. Examples are provided below to help you identify these individuals. Identify the types of ownership interests in your company and individuals that hold those ownership interests. Examples are provided below to help identification. Calculate the percentage of ownership interests held directly or indirectly by individuals to identify individuals who own or control directly or indirectly at least 25% of the ownership interests of the company. Here are additional details on each step. Individuals may directly or indirectly exercise substantial control. Individuals can exercise substantial control through contracts, arrangements, understandings, relationship, or otherwise. Notes for trust. A trustee of a trust or similar arrangement may exercise substantial control over a reporting company. So, if what this is saying, based on that, note for trust, it's saying so if you have an LLC and it's owned by a trust, right? So the trustee will have this substantial control over that. I would rather be in that position than actual direct owner of the company. If it's a reporting company. I'm getting tired of reading this. Uh I am going to. I already formulated a plan. I got a plan. This is not good. I don't like this, but at the same time, I know how to I know how to set this up. That 25% is key. And if you're gonna make your trust the owner of your business, you will list the trustee. But in my group, our trustees are a certain type of trust. Is a certain type of trust. So I'll clarify that through my private channel. Private channel. Sorry, I can't be out here just putting it out there on in YouTube verse. Because we got haters, we got eavesdroppers, we got copycatters. Yeah. If you go, so let me just address something that somebody put in the chat. It said it takes 3 LLC incorporated in closed states owned by a church to insulate yourself. Okay, what that means? Put the business in a trust. I already said that. Be the executive and beneficiary and not owner. Okay. Well, the executor or beneficiary is the beneficiary. You're going to be the one who's the beneficiary is definitely not right because you're going to be the beneficiary of whatever proceeds coming from that company. So therefore, you're going to come in contact with capital gains. Executor, no. It just told you. I just read it. In a trust, a trustee of a trust or similar arrangement may exercise substantial control over a reporting company. I mean, you can say executor. The executor might work and put that, as it. I don't see too much of a problem with that. But it's looking for who has control, and the control that they're looking for is they're not saying it, but the control is who's got control over that money and who's going to give us our share when it come time to do taxes. That's really what they're looking for. They're looking for the person who they can come after if they got a problem with you. That's what this is about. Make no mistake. They want the name of the person that they can come and attack. Not, oh, come and bring parting gifts and, hey, thank you for filling this out. We're your friend now. No, it's coming to, it's out. You put your name on here. We coming after you. You see? Who is they? Who you think is the government? Man, listen, I can't be answering. Who else would it be? Nah, the homeboy around the corner, he'll be coming for you. This is what they asked me. Who is they? the, the government. You put your name on the government coming after you. Who wants you to fill this stuff out? The government. All right. I'm tired of reading. Does your company have a president, chief financial officer, general counsel, chief executive officer, or chief operating officer? I would check now. Does your company have any other officers that perform functions? President, chief officer, general counsel? I would say no, because I see if you have an LLC, you could be a manager of it and not actually an officer. Does your company have a board of directors? No. Does your individual have the ability to appoint or remove senior officer of the company? No. Does an individual direct, determine, or have substantial influence over important decisions made by your company, including decisions regarding your company's business finances or structure? Does any individual direct certain employees who might fit this description are nevertheless exempt? Certain employees who might fit this description are nevertheless exempt from the beneficial owner definition. Let's see. See, this is why you got to read this stuff. Let's see Section 2.4. There are 5 exceptions to the beneficial owner definition of beneficial owner. When an individual who is would otherwise be a beneficial owner of a reporting company qualifies for an exception, the reporting company does not have to report that individual as a beneficial owner in its BOI report to FinCEN. The following checkbox is intended to help your company to determine an individual qualifies for this if the following criterion applies. I got minor child exception. So, or any trouble with the domestic. So they kind of telling you what you could do here. All right. Minor child is one. Nominee, intermediate, custodial, and agent. The individual merely acts as on behalf of an actual beneficial owner, beneficial owner's nominee, intermediary, custodial, and agent. So that's another exception. Employee, the individual and employee of a reporting company when applying the meaning of employee provided, and then it has another code. Read that in. The individual's substantial control or economic benefits from the reporting company are derived solely from the employment status of the individual as an employee. The individual is not a senior officer or reporting company. The term senior officer means any individual holding the position or exercising the authority of a president, chief financial officer, general counsel, chief executive officer, or chief operating officer, any other officer, regardless of official title, who performs a similar function. Inheritor. An individual qualifies for this succession if the following criterion applies. The individual only interest in the company is a future interest through a right of inheritance, such as through a will providing a future interest in the company. So they don't get that. Creditor. The individual, the creditor of a reporting company. The term creditor means an individual who would meet the definition of beneficial owner of a reporting company solely through rights or interest for a payment of predetermined sum of money, such as a debt incurred by the reporting company or a loan covenant or other similar right associated with such rights. So a creditor won't. Mm, that's. I need to. I'm writing some stuff down. No, I ain't got it right because I'll just go back to this. That's this stuff is a lot of in depth. This is it seems like they updated this. They did because it says December 2024. They just changed this version 1.2 because the first version didn't say none of this. See, they switching up on you. Indie Circle, go back and read the rules of. I've read this like so many times. Even though your churches are mandatory accepted from filling out that form, they're still in the eyes of the government are considered a 501c3. They're just mandatory accepted from filling out an application for exemption. I read that I don't know how many times. You still Jedi mind trick with that 501c3 information that people taught. People say, oh, you need to be a 508. 508 is the law that says churches will be treated as a 501c3, but they are not required to file for tax exemption status. See, that's what happens when people teach and they can't read with comprehension. They can read the words, but they don't comprehend the words. Right? That's why you got to read stuff over and over. I'm gonna read it right here. Except as provided in subsection C, any organization, including an organization in existence on October 1969, which is described in section 501c3, and what does not notify at such time in such manner. Let me go back. Why is this? Move this out my way. Okay. Except as provided in subsection C, an organization organized after October 9th, 1969 should not be treated as an organization described in section 501c3. Okay. So let's go down. And that's where it says churches, they won't be treated as the other organizations in the 501c3, but they will have the same benefits, meaning they don't have to file anything. They don't have to file tax returns. They don't have to report. And they don't in churches, temples, mosques, and synagogues are exempt from that. But for the IRS code, they say churches, but that includes all the other three: temples, synagogues, and mosques. All right. They don't have to fill out that stuff. They won't be treated with the penalties if you they won't be treated with the political like those rules that you have to if you can lose your tax exempt status if you do such and such and such. Okay. All right, what time is it? 8:06. All right, so if you got a company, research this, restructure it the way you need it to be, and move accordingly. Well, my people that's in my group, we're gonna have a meeting next Monday, so we'll be talking about this because it's a few days before the deadline. All right, we'll be talking about this in depth because I got some definite remedy for you. All right. All right, let's go back to the. Don't y'all love it that you got somebody that can read these things for you? It's nothing to be. I wouldn't be afraid of this. Yeah, you got to run your business. You got to, man. So if it ain't this rule, they'll come up with something else. All right, I wouldn't be afraid of this. You can just set you up an unincorporated association. It's not a reporting company because most unincorporated associations do not have to file nothing with the Secretary of State. And guess what? Unincorporated associations can get credit. Yeah. Get your EIN and call it a day. Because most, not only time they look at anything filed on the Secretary of State with, um, is when you're trying to get a loan. They want to verify who's who. That's it. All righty, all righty, all righty. All right, I'm tired. I've been running all day, taking care of this, talking about this. The end of the year, I'm trying to. What I'm doing is, it's always good to go over previous year's business and kind of get things in order so that you can see where you want to be next year. And that's what I'm doing with all my businesses. I'm just putting numbers together and so that things can be straight. So we can have a prosperous year next year. But like anything, everything has its challenges. And I always welcome challenges. Now they just part of the business, part of the doing business. All right, y'all. I'm gonna say goodnight. I will probably see you tomorrow night. I haven't really, let me see how I feel. Man, I probably will. It's Tuesday. And it's Christmas Eve. I'm not into really Christmas. I never grew up celebrating it, but people that around me they celebrate it. So I just kind of be the observer. All right, y'all. Peace, prosperity, extreme wealth to you. You guys have a good night. I am out of here. Wait a minute. Let me see something. Let me check something. Before I go. I'm out of here. All right, peace. Yeah, so I think the 24th we're gonna go visit Portugal. Our success and failure is not dependent on what the government do, what Trump do, what Kamala do, what issues she supports and what issues she. Our success is not dependent on that. I can tell you one thing, our failure is dependent on that. Because if you sitting up there looking for them to make changes for you, I guarantee you that's a recipe for failure for you. Because that's not the God you're supposed to be looking at. You're supposed to be looking at the God in you. And the God in you says, don't worry about tomorrow. Because tomorrow has its worries of its own. Do I not feed the birds in heaven? And I know every hair on your head. I can count them. So I already know what you need. I already know what you want. And I'll give you what you need. And I'll give you what you want. All you have to do is put forth the kingdom of heaven first. Then all these things will be added to you.